when misconduct becomes gross. We've heard about misconduct, we've heard about gross misconduct. So the question we are asking today is that at what stage does a misconduct become gross? So to be referred to as a gross misconduct, right? So understanding when insubordination justifies dismissal under the Labor Relations Act. The Labor Relations Act, read together with the Code of Good Practice 2025, establishes that dismissal is an appropriate sanction when an employee's conduct amounts to gross misconduct. While the Labor Relations Act does not list every type of dismissible offenses, it makes clear that the seriousness and intent behind the misconduct, are key factors in determining whether dismissal is justified. The challenge for employers lies in determining when behavior qualifies as gross misconduct and when a lesser sanction, such as a warning or suspension, may be more appropriate. In Palusi Home Depot Pty Ltd versus Herskovets and others, the Labor Appeal Court confirmed that an employee's refusal to comply with a reasonable and lawful instruction or any other deliberate challenge to the employer's authority may justify dismissal, provided the conduct is willful and serious. Insubordination becomes dismissible on a first offense only when there is evidence of deliberate defiance or an intentional refusal to carry out instructions. Employees are also bound by a duty to act in the employer's best interest and to follow reasonable directives necessary to fulfill their duties. A recent example is Department of Correctional Services versus Kutu and others, where a prison guard refused a direct order from a commanding officer to escort a prisoner in need of medical attention. The Labor Court initially set aside the employee's dismissal, but the Labor Appeals Court overturned that finding, ruling that the lower court failed to consider the context and seriousness of the offense, including the employee's prior warnings. The Labor Appeals Court emphasized that assessing whether misconduct is gross requires considering all surrounding circumstances, the nature of the work, the specific instruction, and whether the employee's refusal posed an operational risk or undermined authority within the workplace. Employers must assess insubordination within context. The relevant factors include: number one, the nature of the workplace and the type of work performed. Number two, the reasonableness and necessity of the instruction. 3, the potential impact on operations or safety. 4, the employee's disciplinary record and attitude. 5, whether the refusal was deliberate or justified. Only when these considerations point to a willful and serious defiance should dismissal be regarded as appropriate in the circumstances. Here are the tips. Distinguish misconduct from gross misconduct. Not every act of defiance or disobedience warrants dismissal. Before imposing a sanction, evaluate whether the employee's conduct was deliberate, serious, and damaging to the employment relationship. Record your reasoning to demonstrate that dismissal was proportionate and fair. Tip number 2, apply a contextual, evidence-based approach. Always weigh the operational circumstances, nature of the instruction, and the employee's intent. Ensure that your disciplinary chairperson considers these factors before reaching a finding. This holistic approach aligns with recent case law and protects the decision from being overturned on review. Thank you guys for tuning in. My name is Debos Kosana. The name of the platform is The Labor Guide with Debos Kosana. Please help me to grow the platform by subscribing, sharing, commenting, and joining to become a member. Thank you very much.